It's Wednesday, February 14th, 2024. This is the office hours for the Oregon Defense OPDC, Oregon
Public Defense Commission.
Public Defense Commission. We've changed our name. I cannot get it straight in my head just yet. We are recording today's meeting so that others who cannot be here can access this discussion. Because we are recording the meeting, the recording will, and anything in the chat will be subject to public records requests under chapter or ORS chapter 192. So thank you for joining us today. My name is Shelley Dillon. I'm with the Office of our Oregon Public Defense Commission. And I think if you could all please mute yourselves unless you are talking, that would be great. We'll just go around our conference room here and introduce ourselves. And if you would like to introduce yourself as a guest, please do so. Again, Shelley Dillon, Data and Research Team, been with the agency for 15 plus years. And I'll pass it off to Megan.
Hi, I'm Megan Doak. I'm Program Analyst
I can see you.
with the Trial Support Division.
I'm just by Kim Freeman. I'm the CAP manager, which is compliance, audit, and performance. I've been with the agency since the end of July.
My name's Harry Newton. I'm a research analyst.
Selena Hernandez, I'm a program analyst.
I'm Maddie Davis. I'm a part of the data and research team.
And I'm a little late here, but Alina Haynes, I'm also a program analyst coming from another meeting. So, hello.
So the purpose of office hours is to make ourselves available to PCRP providers for any questions you may have concerning caseload reporting. We have an agenda posted on our website that admittedly is a little bit more focused toward the adult criminal and juvenile contracts, but we're more than happy to make ourselves available to answer any questions that you may have. It's an effort to be transparent, to make ourselves available. So we're going to open the floor up to whomever wants to speak. And if you have questions, feel free to hop in and we can have a discussion. Or if there's something specific you would like us to review with you, we're more than happy to do so. I think the agenda was going to just cover some common reporting errors. The PCRP caseload reports, though, pretty much if you have an error in your report or something that's invalid, the system's going to throw you an error message and ask you to correct your report and then try to resubmit. Are you guys having any issues, or is there anything you'd like to discuss or go over with us?
Was that a hand raise?
Did somebody have their hand raised?
No, it's just somebody coming.
Okay.
Gardner's joining us. Good afternoon, Gardner.
Hello, how are you?
Doing well. We just opened it up for any questions or comments.
Well, I had a question.
Great.
Surprise. It's very specific. It's been asked before, and I just, for some reason, it can't sink into some of our brains. It's a very specific question about reporting, if I could. And it's a question about if we have a open dependency case in Multnomah County, and back in the day, they would eventually file a separate, distinct termination of parental rights case under a different case number. Now they're shifting due to case law to filing permanent guardianships in some of those cases now, as a significant plan that has its own. It's a separate initial appearance, a separate, proceedings, things like that, but they file it under the dependency case number. So it just sits in there inside the case. It doesn't look like a different case, but it's a big change. How do we report that? Is it a separate credit? Is it a change in the type of credit we should be putting on our case count sheets? Anybody? In other words, the dependency case is still open. So is a permanent guardianship case is still pending. And I was reminded again of this issue because there's an initial appearance on that that triggers a brand new thing. But they file it under the dependency case number. And so just wondering what we should do with that.
Can I
Shannon?
wait? That's weird that they're doing it in the dependency case, which I'm probably not telling you there anything that you don't already know, Gardner. Let me make sure we sort things out correctly on our end with the caseload reporting, but I believe we have a separate case code for permanent guardianships, and they are treated essentially like TPRs because they are very similar, right? So we'll get back to you, but that is how it should work. I just want to make sure we have things set up so that it actually does work that way for everybody, but that is the intent. And as far as the sort of slightly odd Multnomah County practice of doing it in the dependency case, we'll make sure we figure out how to account for that so that you all don't experience it. I think it's easier on the PCRP side, the way that reporting is set up, but I just want to make sure with our data research team that we've got that working the way it should.
Thank you.
Gardner, they don't file a new order appointing counsel, do they? They just say that's just like an event in the dependency case?
It is, but the strange thing about it is, you know, we have dependency matters where, say, a jurisdictional trial, it's pre-jurisdictional. And if a parent doesn't show up for a court date, for example, they will proceed against them, do a prima facie, and lock in jurisdiction in their absence. That's one way they can do it, by missing an important court date. You can be floating along and making all your dependency court dates after that and just be plugging along, but they'll file an initial appearance on a permanent guardianship within the thing. So if your parent makes all the other dates in the case, all the other dependency matter dates, but they miss that initial appearance on the permanent guardianship filing, we don't get a new appointment. But if they don't show up, they're basically, their case is over in that instance. Like they're basically part of a permanent guardianship, and they have no further, they'll in that moment, they not only manage the permanent guardianship, but in that one fell swoop, they will eliminate the caseworker, all the attorneys and everything, because they're no longer needed on the case because now a guardianship is in place. So
Okay. Could you, because this is a public recording, could you email your program analyst a couple case numbers that we could look at what the
Sure.
court record is reflecting, and then we could follow up with you about that? Because I don't believe it's our intention to not allow you to have credit for those guardianship cases that materialize, regardless how the court is organizing them, whatever court number or file. So
right.
I think we would
And
like to be able to look at it and get back to you.
Sure. And one final point, if I could, separate and distinct from our case counts, just so people are aware of it. It's like as a policy, so you understand like ups and downs of caseloads in different counties. What used to be TPRs by and large are vanishing rapidly, and they're turning into permanent guardianship cases due to appellate case law. So we're getting fewer and fewer termination appointments, and we're getting more and more permanent guardianships. It's anecdotal. I don't have the exact numbers, but I just want you to know that's shifting kind of how it looks, what's in our county, if that
Sure.
matters to anybody.
Oh, it does matter what's happening with our caseload reporting numbers. And if there's a case law or something new that's come down, we try to keep track of it. I know the lawyers in our office keep track of that stuff a little better than data team members, but that's why we all work together so we can make everything match. But thank you for that. Mhm.
Yep.
Okay, and who is Multnomah's pro?
It's me.
It's Alina. Okay, so will you email Alina a couple case numbers, please, Gardner, and we'll take a look at it and try to follow up.
I will do that. I won't do it right now. I'm hoping that's not what you're asking.
No, just in the near future.
Yep,
Okay.
no problem.
Okay, thank you.
the hand up.
Someone has their hand up. Chad?
Hi there, this is Chad with Youth Rights and Justice. I just wanted to speak because I've been having the same issue in Multnomah County as well for the exact same deal with the perm guardianship petitions being filed in a dependency case. And I think I reached out about it a few months ago when it first came up on one of our cases. And I could dig through my emails and find it, but I think I was told to just report it on a separate line. Same client, essentially most of the same information, but coding it as a guardianship case type, adding the additional credit. And then it seems like maybe the AAGs are catching up and they're at least assigning a separate petition number that's different from the dependency petition number. So I'm putting that in as well. But I guess just if you guys make any decisions, it's going to be different on how to report that, because I think I've probably submitted 3 to 4 monthly reports with those additional credits in that way. So if there's like a different method, I'd like to be kept in the loop on that as well. I think that's
Absolutely. I think if you could find the email with whomever gave you that guidance, I think our data team would be interested to review that as well. And maybe
Yeah.
Alina knows that, or maybe, I'm sorry, Alina, I'm asking everybody to contact you, then we can follow up. Since she's the program analyst for Multnomah County. That would be helpful, Chad. Thank you.
Yeah, I can do that. And one other question was just, I guess I don't know when to stop reporting that, because I'm just not sure if the DHS side of things, if we'll get like when it develops into a full guardianship, or we just continue to count that extra credit until case closes on both ends. And I guess just one last specific question I had. Sorry if I can check my notes here for a second. I actually emailed about this to Elena too, and this was just yesterday, so wasn't expecting a quick reply back. But I was curious, we're getting a lot more out of county cases, and for delinquencies that go to post adjudication for out of county, are we supposed to report at that point 1.5 credits, or do we continue to report 2 credits since we get an additional one for out of county?
Chad, are you referring to the juvenile post adjudication cases?
That's
Like
right.
the JPAR matters? Okay. Yeah, we actually discussed this earlier today, and this is the first time that we've connected with our data team. So I wanna bring that forth and make sure that we're all on the same page, but and I can follow up with you on what that recommendation is, because it is it's our understanding that those are all, because even though it's a juvenile post adjudication case, you're starting them as you're starting on the work on a brand new case, so it would be considered predisposition weights per the PCRP contract. But I'll make sure that if there is somewhere in our reporting instructions that we can point to on that, I think that this is a fairly new layer to that, and it's completely understandable why you reached out to confirm how to report these.
And that might be a good thing to update if we're commonly asked questions about PCRP reporting. So
yeah,
we could maybe formalize something in the manual or a resource section on caseload reporting.
Okay, thank you. And most of these we've gotten in the past month, so it wouldn't be as like no rush essentially, because it won't be needed till the February reporting period, just for me to know what credits to apply. Thank you.
Thanks, Chad.
Go ahead, Gardner.
Hi. Since it's quick and not a big ramble on my part, I was just checked a case that I know I have and looked it up real quick on a permanent guardianship. The case number.
Okay, hold on. Excuse me. Is it okay to say the case number? It's a juvenile matter on a public recorded.
I don't mind sending an email with all the additional information. I was just going to point out one thing that was answered the question.
Okay.
The question was it at least a different petition number? The answer is no, it is not. It's the
Okay.
same petition number as well. It doesn't, that they file it under.
Got
But,
it. Sorry, I was
just throwing that out.
concerned about putting a juvenile case number on a public record. That's all.
Yep.
I'm
not
a little
saying-
paranoid.
It's a secret.
Okay. Thank you. Sorry. Okay.
Thanks.
Mhm. Well, does anybody have any other questions? Program analyst or any comments about reporting or anything? We certainly want to respect your time. We want to make ourselves available, but we just don't want to sit here in silence either. And we just don't want to give you an opportunity to just to, you know, make things up. But if anybody has any specific questions or comments, please feel free to chime in. Matt?
Hi, this is Matt Washuk. I'm also in Multnomah County. And I'll just say, following up on Gardner and Chad's comments, we also have been reporting, I think, for like a year plus on the permanent guardianships as a separate line item, same case number, but a separate code saying permanent guardianship. And we haven't received any feedback from OPDS that it's coded wrong or that it's screwing up, you know, the any of the data calculations. Happy to change how we're doing it, but I believe that's what we were also instructed to do. But kind of on that note, you know, with one of the things that Gardner said, and I just wondered if OPDC has a particular thought about this, or if there's just not, because I don't know what happens in other counties. Until about, I don't know, a year ago, a year and a half ago, when you represented a parent and a termination petition was filed, when a judgment comes down, assuming it terminates the parent's parental rights, you know, what will happen is the judge hearing the termination case will keep a parent's appointment around for 31 days so that the attorney can assist the parent with filing an appeal or a request for an appeal if that's what the parent wants to do. And we kind of had varying ways that judges handled the underlying dependency petition, because of course the underlying dependency petition continues until the adoption occurs. And a lot of times as a parent's attorney, what we might be doing still with the client is assisting them with mediation, ensuring that it's happening, that, you know, they're getting a reasonable result, that it's getting put into the supplemental confidential file and is being made part of an adoption judgment. Sometimes we're dealing with post-termination visitation issues. And generally, I would say that I feel like in Multnomah County, the judges have continued to let us represent parents in those situations. But what's happening now in OECI is that once a parent's parental rights are terminated, that parent is just removed from the dependency case as though they never existed. It's not as though the parent's name is still there and they're crossed out and the attorney's name is still there and maybe crossed out. It's like the parent never existed to begin with. And so you can't look up a juvenile case via a biological parent once their parental rights have been terminated, only the child's name. And now the judges, I feel like I've had several cases over the last 12 months where the judges just aren't sure what to do about our representation any longer since we're not an OECI. And I didn't know if OPDC had a particular position on whether or not the agency thinks we should be continuing to represent parents in that scenario and whether or not an appointment should still exist for us.
Okay, thank you for explaining that scenario. Shannon Flowers is coming back online and I'm going to defer to her. But I would say before she speaks to our position on should you represent the person, I would think, again, it's always best for the data team if we have some OECI examples to look at. And so that perhaps we could understand what the court is doing to the public interface of that case, particular case record. So again, for Alina, if you could email her some case numbers that we could take a look at also.
Well, and I should be clear too, just to clarify, when the judge in the termination case terminates our appointment, they're only terminating our appointment on the termination petition. No one's touching the dependency petition either way. And so, you could have a review hearing on the dependency petition 3 days later or 5.5 months later, but no judge is touching your appointment in it. But they're removing the parent from OECI, so they never existed, and we're not really there anymore. And we don't get then notices of discovery either, when they're being discovered through OECI or that notification system. So it's just not really sure how to handle that.
Yeah, thanks, Matt. So I think, learned that this might, so I think maybe in November or December, we first heard about this practice, and it was in a different jurisdiction. Did not know then whether or not it would be widespread. Was it one court doing this, or is it going to be across all courts in the state? And it sounds like it is an OJD practice change from what you're saying. I think there's a bigger conversation maybe that we need to have with OJD around this, because when I learned about it, I had the same or similar concerns that you expressed, in that the parent is not technically a party anymore, but that doesn't mean they were never a party. And it definitely, there's potential for problems on our side of things. If it looks like this person was never part of this case, there was no attorney for that person, it definitely can jam up the works. So I don't have an answer for you on it right now. I think they're, like I said, technically, once a parent's rights are terminated, and after, the appeal, the period for appealing has passed, they're really not a party to the case anymore. But your obligations as an attorney may not be tied strictly to whether or not you were technically appointed. So I think there's some gray area there, and I think there's some stuff we need to figure out. But sorting things out, I think it's very problematic for people to just be eliminated. As far as what you can see, I'm saying publicly, these are confidential cases, which is another wrinkle that makes it all the weirder how this is going. My understanding is that on the back end of things with OJD, you can still see that parent who you can't see on your side of things as a party, and you can't search, but OJD can pull that information. So it's a very long-winded answer. For what I'm really getting at is we'll just have to get back to you. I think there's some legwork that we need to do on our end of things.
Sounds good. And I will just say, I have at least one case right now where the parent does have the termination judgment on appeal, and at least that doesn't impact how OJD handles things or how they do it with OECI. The parent is still removed, and so it's at least the way that they're handling it for us doesn't seem to change if a parent has filed an appeal versus if they haven't.
Okay.
Sounds like we need to follow with OJD to see what their current business practice or business processes are for these matters, and why the change, and so we can better understand.
Yeah, well, if you, in any other type of case, if you had somebody who's no longer a party, you wouldn't just eliminate them from the record, which is the sort of I think it's more than just how is data recorded? There's a bigger question here. So we'll follow up with OJD and then follow up with all of you.
I had something, because I just can't stop myself, related to that, which is along those same lines. There's a different issue, which is it used to be seen as they're no longer a party to the termination of parental rights case, and they're actually still a party to the dependency case. I know that's kind of mind warping, and it may not, and the question is, Because of that, we would have to submit either a request in court at that hearing 3 days later, if you had a dependency review, say, there's nothing to keep me on this case. I'm not requesting to help with anything at this point. Please get me off this case. And then they could terminate your appointment on the dependency matter. And now the question is, do we need to do anything? Do we even need to submit a withdrawal of, our representation on dependency matters? Because we're not taking any action to do that, to get off the dependency case. The termination judge who handles that judgment is not doing anything legally to terminate our appointment on the dependency matter, but it's like it just magically vanishes, as if people somewhere in the magical ether has just taking us off that case, and if the case never existed, the dependency matter. And so that's another aspect of it. It's like, I think as attorneys, we're like, do I still need to file something even though it vanished? Like, what was the procedure for making it vanish? Did somebody decide my appointment has ended? Who decided that?
Well, I pulled up the statute 419B875, which lists out who are all the parties to the case, and there are so many. But if your rights have been terminated, this is sort of my analysis, just thinking through it on the fly a little bit. But a parent or a guardian is a party. If your rights have been terminated, you're not a parent. I guess the point I'm getting at is, like, I'm not sure from our perspective that whether that you are technically appointed or not, in this circumstance at least, your obligations as somebody's lawyer may not conclude just because the court has taken action or not taken action. Are you tracking what I'm saying, Gardner? I'm a little bit all over the place, but that's why I don't understand the practice that OJD has shifted to now, because again, that parent was a party to the case. They just are no longer, but that shouldn't be wiping them out from the record as though they never existed. So we'll try to see what we can learn from OJD.
I was going to add another aspect to it, which is real quick, which is it's not just the attorneys who are represented to the court. I want to stay on this case and assist my client with certain, like, mediation. We've had cases where we go into the courtroom of the dependency matter, say days later, whatever, a week later. And when you show up, you say, I'd like my appointment terminated. Their rights, my appointment terminated as their attorney on the dependency matter because a week and a half ago, their termination occurred and blah, blah. Or maybe, 30 days later, if you're waiting for some consistency with the appointment on the termination case. And there are judges or judicial officers in Multnomah County who have on occasion said, I'm going to keep you on the case. I want to keep you on the dependency case. And I think you could be valuable in assisting with this thing that's coming up right now. And they've actually not even accepted our request to be taken off of cases. That's rare, but it's happened. And let me tell you off the record some other time about a client whose rights were terminated and I remained on their case because of all sorts of strange things and adoptive placements, blowing up, and suddenly the kid needs to be moved. So then they wanted to do a new mediation with the new placement resource. And they thought they owed a duty as the agency, DHS, to the parent whose rights were terminated, expecting mediation with the adoptive resource. They had 3 separate mediations with 2 blown adoptive placements over the course of, wait for it, 18 months. So that's bad for the kids, but that was an extended dependency appointment on a termination that had occurred 18 months previously.
Yeah, we can talk offline separately sometime, Gardner, but that also seems problematic. Yeah.
Right. Okay. Well, then I will leave it at that.
Matt, did you have a follow-up? Your hand is still raised.
Oh, sorry, I just forgot to take it down. No, I'm good. Thank you for your answers.
Well, it's now 12:32. Sounds like our office has some follow-up and some research to do to report back to the PCRP office hours meeting. If there are no other comments or questions, we will call the meeting and give you guys back a half hour of your day. If there are no objections. All right, thank you all for coming. I appreciate the feedback, and we will do our research and follow up next office hours, which is sometime in March. It's on the website. I don't have it off the top of my head. But hopefully we can come back next office hours, if not before, with some responses to the inquiries that were made here today. So this is very helpful and meaningful. And thank you all very much. Have a good day.